fresh admission item number 1.
May I please, your lordship? Here I have challenged the annexure 6 matter. The background of the case is that the petitioner is a allotee of a IDCO land in the Autonagar Industrial Estate, Berhampur. He is carrying out a garage over the plot, my lord. Now want to change the activities from garage to a restaurant. Earlier on, my lord, kindly have a glance to annexure 3. He has applied for a changing the activities from garage to conventional hall, my lord. That has been forwarded to the tourism department. And tourism department under annexure 4, page 39, returned the proposal saying that the land is not sufficient for the conventional hall and advised to for other activities, my lord. Immediately thereafter, under annexure 5, and next page, annexure 5, the petitioner has applied for changing the activity from conventional center to banquet hall. That has been rejected under annexure.
Division bench at all? What is in it for division bench? Why is it a division bench matter, sir? Any idea?
No, my lord.
No. For a division bench.
It may be taken up after
How did it
vacation.
go to a division bench. Normally go before a single judge, right?
Yes, my lord. Lady,
All
after
right.
vacation,
It appears that this is
after vacation, any
it appears this is not a division bench matter at all. List before the roster bench of the learned single judge on 23rd June. All right.
Item number 2.
May plead your lordship.
Yes.
Which is the matter is regarding PIL nature my lord. That is the opposite party and opposite party number 4. That is the private person is constructed a land in the Gochar land. My lord. Constructed building and Gochar land. My lord. That after the villagers are facing some problems, my lord. Gochar and the construction of the Gochar land, the villagers are facing some problems. That is the file a grievance before the villagers are file a grievance before the OP number 3, my lord. That is the Tahsildar, my lord.
Where which page is that?
Page 15. Page 15.
Annexure 2, my lord. Page 12.
15 is the up to date.
The grievance is before the OP2, the opposite with Tahsildar, my lord. That
Where is the acknowledgement?
villagers.
No. The second representation, there is an acknowledgement.
Okay, petitioner's representation annexure 3 will be examined by the Tahsildar, Pattamundai, and after notice the petitioners and opposite party number 4, and giving them a hearing. A reasoned order shall be passed not later than 14th August and be communicated to the parties within a week thereafter. The court is not expressed.
Item number 3.
The land in question was acquired for the purpose of facilitating irrigation facilities to the villagers of Odospur. And the classification was also changed, but as government land. But the same was recorded in favor of a private person, and taking advantage of that recording, the opposite party number 8 has already sold a portion of the government land and now is bent upon to dispose of the other part, my lord.
You made a representation.
My lord.
Have you made any representation?
My lord.
Where is that?
My lord, that annexure 5, the villagers have sent a notice through their lawyer.
All right. The petitioner's notice oblique representation bracket annexure 5 will be examined by the again Tahsildar
near
Kantapada.
Kantapada.
Notice the petitioners and opposite party number 8 and giving them a hearing. The reasoned order shall be passed not later than 14th August and communicated within a week thereafter. All right.
Item number 4.
On behalf of K. Pradhan, my lord permitted to withdraw.
Dismissed as withdrawn.
Item number 5.
May I please, your lordship. My last occasion, your lordship directed to file an appropriate application for impleading the encroachers as party to this writ petition. Madam. And pursuant to your lordship direction, I have filed an petition for amendment of the writ petition, including the encroachers as parties. And
Or
that I
I
am
is
allowed.
allowed, and then you say the petitioner's representation.
No, my lord. Your lordship are earlier directed for the same, my lord. It was the second round litigation, my lord.
All right.
My lord,
All right, notice, you see.
My lord, copy has not been solved.
Yes, yes.
Right, right.
No, no,
Mr.
no.
Mohanty,
yes,
notice,
leave
Copy now.
On
Not
behalf of-
you give another copy.
opposite parties 1 to 3. Notice will now go to the freshly added parties, returnable
obliged.
on
Give another copy.
3rd August.
Item number 6.
May I please, your lordship? My lord, the limited grievance of the petitioners that they have submitted a representation before opposite party number 2 that may be looked into, my lord. They have assailed the action of the opposite party regarding construction of a rural park over a playground and a butcher land, my lord. There are sufficient vacant land which is
All right, the petitioner's representation Annex 4 will be examined by the
opposite party number 2, my lord.
collector Jagat Singh Pur and after notice to the petitioners and opposite parties 6 and 7. And after giving them a hearing, the reasoned order shall be passed not later than 14th August. Will be
Obliged.
communicated to the parties within a week thereafter.
Obliged, your lord.
Item number 7.
May it please your lordship. What is the limited grievance of the petitioners who are the villagers is that, my lords, the opposite parties are making some construction, cutting down the trees, my lords, without addressing the objection of the objection annexed
Petitioner's
to
representation Annex 2 will be
two
examined
series.
by the
The DFO में opposite party number 5.
Additional first officer Khurda, bracket opposite party number 5. And after notice to the petitioners and opposite parties 7 and 8. And after giving the hearing, the reasoned order shall be passed not later than 14th August
I'm obliged.
and we communicate to the parties.
Item number 8.
My lord, one post of member in the Odisha Human Rights Commission is lying vacant. Even after 3 months, as stipulated by the Honorable Supreme Court, within 3 months, the post-
After Justice R.V. Das resigned, that is not fulfilled. But other 2 posts are filled up. The bench is
Alright.
going on
It appears
smoothly.
that one member's post in OHRC is still vacant. Mr. Mohanty states that he'll seek instructions. List on 3rd August. It's expected that by that date, the remaining vacancy will be filled up. All right.
Item number 9.
my lord, next date.
3rd August.
Obliged.
Item 9.
Item 9, no instruction, my lord.
No instructions.
Item number 10.
10 pass over, my lord.
All right.
Item number 11.
Item 11 and 12 UGC matter fixed to 24th August.
All right.
Appearing for the respondents, my lord, in these 2 cases.
I'll start copy.
All right. Notice same order. List along with it. These are fresh matters.
Yes, fresh matters.
I see. All right. Same order. You put his appearance for opposite parties.
Item number 13.
My lord, item 13 and 14, my lordship, my portion of my lord's order, that I have taken the step for a legal representation, that the appellant number 2 died, my lord, leaving behind the sons and daughters. That I have filed.
You've not, it says it's not taken, steps not taken.
My lord, I have filed the miskesa with the condemnation delay for
What
substitution
number,
and
sir?
also
What is the number?
Number कितने?
number, my lord, 2695 in 269 of 20 writ appeal 2695 2696 2 miscases filed, 1 condemnation of delay and another is for substitution.
Okay.
And in other case, my lord, that is the 2
Just show him the paper book. It's there.
I have served a copy of the state, my lord, and also yesterday.
Just help us take it out, sir. Take out your application.
This has not been tagged, my lord. Yesterday I have filed this such case,
Oh,
my lord.
yesterday.
Yesterday I have solved copy, my lord. To the state, my lord, due
Counsel for
to
the appellant states that only yesterday has filed the substitution applications.
substitution,
Maybe
copy have been
product
solved and delay continuation also.
What list on? July.
21st July.
25th.
25th.
My
25th.
matter and 14, my lord, 13, 14, same, my lord.
Okay.
In 6 cases, my lord, I have already filed. With the death certificate and
Item number 15,
No, 25 July.
item 15,
None appeals.
item number 16,
My lord, in item number 16, I am for the appellant, your lordship may see my lord's order dated 26/9/22, where your lordship had directed the furnish the paper books to the Secretary Orissa High Court Legal Services Committee for engaging a lawyer for 10 years experience.
Nobody's been engaged.
My lord, I have entered appearance, but my name is not reflected, my lord.
What is name? Do you know the name?
Asu occasion for it, reply that.
Your names.
Himanshu Bhushan Das.
Or name of so and so be indicated for the respondent. List on 3rd August.
My lord, the interim order is there. I pray for this
Interim order to
continuance. Obliged, my lord.
item 17,
None appeals dismissed.
item number 18,
Same.
item number 19,
May I please, your lordship? My lord, this is matter related to regularization of service. My lord, identical matter, my lord, has already passed order.
Well, what I pray, my lords, I am appearing for respondents in all these cases, my lords. Your lordship may kindly direct the, your lordship may kindly set first the disposal, my lords. Your lordship may set as the order passed by the Honorable Single Judge, my lords, and remit the matter to be listed upon 7th of August and to file the paraphrase replies to the appellant before on or before 24th July, my lords. That order.
All right. Same thing. The same order. That's what it's showing. Same order. In all these matters.
One copy of the
Obliged.
item number 20,
Item 20, my lord, say, heading of removal of defect, my lord. I have already given the copy to state, my lord. And
What is the delay?
my lord, and there is a delay condonation petition, my lord. Virtually, there is no delay because
Or
of
delays come to the matters and
my lord. So, in a RP, there are 19 RP cases, my lord, and I have annexed at page 11, my lord. At 11, my lord, and my lord, order has been passed in that the OP5 has no right in the disputed land, my lord, and your one of the RP case that has been challenged before this honorable court, my lord. Your lordship has already granted stay, my lord, there. In writ appeal number 3 of 23, my lord.
where is the order? Show us.
Same matter, my lord, and
All right. Same order.
it has been posted to 18 July, my lord,
List along with
along with writ appeal 3 of 23, my lord.
3 of 23 and 18 July. All right.
Petition is there, my lord.
Same
17
order.
of
Same order.
item 21,
Please, no,
21/22, there's a limitation of 40 days.
All right. What's the
I have
matter?
taken steps.
Yeah. What is the matter?
My lord's matter is that these are contract teachers. There was a BPUT board notification giving them some enhanced scale. These teachers are actually BPUT board would pan across all the colleges, technical colleges.
our college was being a government college, Keonjhar Government College. We needed approval of the government. We could not have granted it only on the basis of the BPUT board notification. So we referred it to the government. It took 2 years time. Moment government cleared it, my lords, we started giving. So they are now claiming for that intermittent period of 2 years. So I leave it to your lordship, my lords. Lordship,
Yeah.
record
The scope of the dispute being just about arrears of salary for a period of 2 years. There is no substantial question of law that requires to be considered with this court. Clarifying that the impugned orders will be treated as being peculiar to the facts of the case and will not constitute a precedent. The writ appeal is dismissed.
grateful. 22 also.
Delay is conduct. Yeah.
Item 23.
Lordship, I record my appearance in this.
Yes, of course.
23, my lord, there is a delay and notice has been issued. So far, respondent number 1 is concerned, my lord, nobody has been appeared.
They are not supposed to defend their orders, sir.
And one more thing, my lord, another similar writ application, writ appeal, my lord, your lordship has entertained and admitted the same. Same, the 2 officers has been penalized. One of the officer before my lord and that has been granted. Admitted the appeal.
Fresh notice to respond to returnable. When is this listed?
Pardon? 7/4/2022.
7/4?
2022. This
22. No, when is the matter listed?
that my lord I have to check now. I will just now check and see when it was listed.
Just check the date. Notice returnable 3rd August. List along with the returnable. Fresh notice returnable 3rd August. List along with 61.
Well, I will take notice within 3 days.
All right.
Okay.
Item 24.
24, my lords. The noting is on R2.
No such person.
No. Yes, this address was taken from the section 11 petition.
Tracking report shows you are appearing.
My lord, I am appearing for the company now. The company is under the CIRP, my lord.
Oh.
I am the resolution professional.
Oh.
So I am to represent the company, my lord. I am representing, my lord.
All right.
Well, I am representing the company, my lord, now.
Okay.
The company is under the CIRP.
Right.
Moratorium, my lord, claimed. Thereafter, my lord, the COC has been, my lord, constituted. And during that time, my lord, an arbitration proceeding which commenced because of the, my lord, section 11 application being allowed by this honorable court. An application was filed before the honorable arbitrator, Mr. M.M. Das, my lord, that a counterclaim ought to be adjudicated. It was decided by Justice Das that counterclaim cannot be adjudicated here because of the Miller bar under the Miller IBC. That was challenged before this honorable court, before the honorable single judge. No, honorable single judge had no, both the matters could be taken up together. I mean, both the matters cannot be taken up by the arbitrator. And that has been, a review application was filed and the review has been admitted in that case. But in that view of the matter, the arbitration has to proceed. Because against the corporate debtor, no proceeding could be initiated. But there is no bar for the corporate debtor to initiate proceeding for getting the money back. Or once a public announcement is made under the IBC, then whoever is going to apply as a resolution applicant.
No, the company is the debtor.
Company is the debtor, So there is no
2,000 crores. 2,000 crores counterclaim. My lords, I am for the department. I was only the facilitator. I was not even the, my lords.
Who is appearing today?
Well, then there
Mr.
no
Das
counter.
enters appearance on behalf of the respondent and informs the court that the respondent is now in before the NCLT.
Yes, well, I'm giving the date when the CIRP got it.
Let a return be filed.
You don't have to mention all.
Well, 22nd of December 2021.
All right. Before this NCLT, and that who's the resolution professional?
Well, I am appearing for.
And Mr. Das himself is the insolvency.
No, I'm not. I'm appearing on his behalf.
What is his name, sir?
But Devendra Umrao. Mr. Devendra Umrao.
Mr. Devendra Umrao is the insolvency resolution professional appointed who will be defending these proceedings. A complete set of the paper books has been served.
No.
A complete set of the paper books be served on Mr. Das today itself. List on 3rd August.
But in fact, on Mr. Maharana, I cannot receive ballot.
All right, Mr. Bar. All right.
I'm sorry.
Right.
Grateful.
Item 25.
May I please, Mr. And for the appellant, it has become infructuous.
All right. The appeal is disposed of as having become infructuous.
Infructuous.
Yes. All these appeals.
Actually, infructuous it has become.
The second and third matters are.
In the second and third matter, in fact, your lordship had directed and disposed it of, saying that the director since heard the matter and lordship closed that matter and disposed of. Now the problem is director had heard and posted for orders. Again, he has reopened it. So therefore, what in fact my friend wanted to challenge the very jurisdiction of the director. His case was that let the secretary hear this matter. I was going to concede with your lordship that let the secretary hear the matter. Now the whole problem is director is not disposing the matter by.
But let it go with the single bench. The connected matters is a list for the roster bench of the learned single judge.
That's right.
On 21st June, opening day. All right.
Item number 26.
Done.
Item
26.
Outsourcing 8th August.
8th August.
Item 27.
May I please? But this case relates to an appointment of assistant professor in dental college. The selection process started in the year 2018. My lord, thereafter,
There's one defect, sir.
My lord. Well, there is delay, my lord.
The defect is also there.
No, defect is about copy not served.
Copy solved, my lord. Solved.
Copy has been served. All right. All right. Tell us the matters.
My lord. There was an advertisement in the year 2018, my lord, for this appointment of assistant professor in government dental college, and OPSC rejected candidature of few candidates for not having eligibility criteria. They filed cases before this honorable court. And my lord, finally, that due to pendency of that court case, the selection process was not over. Even though selection process was over, the only result was to be published, that was not published. Finally, my lord, those cases have been disposed of as per Annexure 6. My lord, may I draw my lord's attention to the relevant portion, ordering portion, that is at page 49. May I please, my lord?
Right.
49, paragraph 27, my lord.
Yes.
The only objection of the petitioner to the selection process is Rule 4 of the Odisha Medical Education Service Method of Recruitment and Condition Service Rules 2013, wherein it prescribes 3 years experience as tutor or senior resident from any medical institution recognized by Medical Council of India, which as per the petitioner is additional qualification over the above the minimum qualification prescribed by Dental Council of India regulation, which is quoted below. My lord, should I skip over, my lord?
Pursuant to the impugned order,
my lord,
you called for the selection.
My lord, I was shortlisted. I have sat in the interview. Only the result was to be published, and from there it has been stalled since 2018.
No. Pursuant to the impugned order, sir.
My lord, here
the order is 23rd December 2022.
My lord,
page 51.
Sorry, my lord.
If you come to page 51, sir.
51, my lord.
This impugned order is dated 23rd December 2022.
My lord.
The last paragraph, para 31.
My lord. In view of the above, all the writ petitions are partly allowed to the extent allowing the petitioner to participate in the recruitment.
You were one of the petitioners, correct?
No, my lord. I was not the petitioner there. I was intervener there. I was intervened. This writ petition was filed by the candidates who were declared ineligible by OPSC. I was declared eligible. I have participated in the process of selection. Selection process is over. The result was to be out.
All right. You just find out then what's happening.
Yes.
So far, the prayer of the appellant who was an interviewer.
My lord, senior is appearing for OPSC.
Kindly see, he is seeking direction to OP number 2, the OPSC. Lordship, kindly turn to page 10.
Yes.
The second part. And further be pleased to direct respondent number 2 to declare the result of interview dated 12/9/19 for the post of assistant professor in the discipline of conservatory dentistry pursuant to advertisement 13 of 1819 immediately. Your Lordship then kindly turn to page 51. Page 51.
Yes.
He has got the relief.
This is a
Paragraph 29.
petitioners have got.
Yes.
He's the intervener.
No, my lord.
No, my lord. What
Just
exactly
a-
has?
just a minute.
Sorry.
My lord, what is the petitioner? Some petitioners, they challenge the advertisement saying that you are taking the qualification from the OMECES rule, Odisha Medical Education Recruitment Rules of 2013, but it should have been under the Dental Council of India that rules. But here that has been rejected by this judgment. But for future, they have been directed to be considered by the government. If the government gives the requisition in the future time, then that will be done. But so far, their cases were stalled because of this case was pending. For them, it has been observed in paragraph 29 that since that are in selection, it has been concluded, interview, everything has been concluded. So, Lord, after that, we'll work out the process and we'll do the need.
Ultimately, those writ petition has been, their prayer has been rejected. And what OPSU has to do to continue with the process of selection and declare the result.
Yes.
But even though this order has been passed in long back in December, the results are not being
No,
published.
that will do that.
Man,
That will
I am the beneficiary there. I am one among those.
You undertake to publish his result.
There is no impediment, my lord. They should have published.
Because
Then why file a writ appeal, sir?
Because, my lord, I have sat in this election, my lord, for no fault.
If you have succeeded before the single judge, why would you
No,
file?
I have not succeeded, my lord. I was intervener. The petitioners, those who filed, they didn't succeed there. They had stalled it. Process of selection was stalled by the ineligible
What in
candidate.
this order is against you?
My lord, here this writ petition.
Nothing against them.
No, my lord. No, nothing against me. That's
Why
why.
file a writ appeal?
There is a case where that has been tagged. My case has been tagged in this batch of case where my prayer was to declare the result. That was tagged in this case. Ultimately, the honorable single judge was to and finally had to direct the OPSC to declare the result, which has not been.
So, is there anything in the impugned order
My
which
lord.
is against you?
No, my lord.
But how can we?
But no orders in my writ petition has been passed. That is what my case is. Had that been passed, the result would have been out.
What was your writ petition number?
My lord, 6312.
You just now said you were an intervener.
My lord, in the first case, I was in the intervention in the first case. There are number of cases. Another case, last case, 6312 of 22, it was tagged there. The prayer therein was that I prayed that as there is no impediment in declaring the result, result should be declared. My lord, ultimately the writ petitions were dismissed. Finally, the honorable single judge was to add this line saying that as because these petitions are
So,
disposed
why
of,
don't we record your submission that you will declare the result?
there is no.
Let your lordship give some time so that I can ascertain because there is some communication between the government and the
That's what I
OPSC.
started dictating. You stopped me.
But
The grievance of the present appellant is that the prayer made by the appellant in writ petition civil 6312 of 2022 for declaring her result was not dealt with by the Lord single judge. Paragraph. Mr. P.K. Monthilan, senior counsel appearing for the respondent.
Number 2.
Odisha Public Service Commission seeks time for instructions whether the appellant's result can be declared. At his request, we'll have it in the opening, sir. 22nd June. All right. 22nd June.
Item number 28.
At 20 rehabilitation. My lord, may I pray, my lord? My lord, may this order be passed that this pendency of this writ petition may not be a bar for the OPSC to declare in the meantime because there is 1 month.
That's what you said.
Nothing like that required.
Yes. All right.
28 the rehabilitation matter 30th August.
30th August.
29.
29 with 26th September.
All right.
Item number 30.
It is only in regards to permanent alimony. Appellant is the wife, appellant number 1 and appellant number 2 is the son. And the respondent already remarried since 2018. I have given the calculation sheet on the last date. The income of the appellant and the IT return, everything has been enclosed. And I have claimed that permanent alimony for the appellant number 1 wife and appellant number 2 son.
Unsuccessful. Mediation is unsuccessful. All right.
Milord, this case after failure of mediation, I have filed this case which is not on board. That is I number 162 by 23, wherein I have prayed for a direction to the other side for filing an affidavit disclosing her source of income, because now the matter has come up for adjudication before your lordship.
Which IA number?
IA number 162 by 23, that is not on board.
It is, my lord, it is not required, my lord. He has not sought a copy. He is filing a copy.
1 minute, just listen. The report of mediation states that it was not successful. Counsel for the opposite party states that he has filed an IA.
Yes, my lord. 162 by 23.
162 by 23 for directions. Copy thereof is served on counsel for the petitioners. List along with the said IA.
Let him pay. Let him pay the cost, because he is filing IA one after another and lingering. No payment has been made. And I have giving the source of income of the appellant number 1 just now. I am showing it. I have already given calculations since last date.
On 3rd August.
Your lordship may pass on order on permanent alimony, section 25 and section 27 of the Hindu Marriage Act.
Give back you. All right. Reply to the IA when he be filed before the next date. 3rd August. Right.
Madam, which date is fixed, my lord?
3rd August. 3rd August.
I pray a little bit earlier, my lord, because appellant and both are wife and son, and he has already got remarried since 2018.
All right, 23rd June. All right.
23rd June. Item 31.
31, my lords, by virtue of your lordship's order dated 14, order number 14 dated 24/2/2023. Your lordship directed, it is stated, though para 7 of this order, above order, this court had made it clear that the policy changes, if accepted by the ASI, will not affect those who have already been granted license under the 2017 policy. The license part, this relates to their content, my lords. But the meat of your lordship's order, earlier order, my lords,
photographers,
my lords, that your lordship had asked them to frame a scheme, para 7, in the circumstances of your lordship's order number 12.
Yes.
Dated 28/9/2022.
Right.
In these circumstances, a direction is issued to the ASI to consider the above request of 154 appellants and examine whether there can be a one-time exception provided for those who may not have matriculation certificate but have been issued an identity cards by the Department of Tourism, Government of Orissa, to be considered for grant of license even in terms of the 2017 policy, while fulfilling the other requirements of that policy. An affidavit on this aspect be filed by the ASI before the next date. If there's a concern from the side of the ASI as to the maximum number of photographers.
Has ASI filed an affidavit?
My lord.
No, they have not. They have not.
My lord, so far as policy decision is concerned, the matter is pending with the Director General. It has been 2 days back, one high-level meeting was conducted to take a decision. But till then, no decision has been taken. Let some time may be granted.
My lord, my humble submission would be the first right to read petition is mine. Here, my lord, pleases to pass an order that those who have identity card issued by Tourism Department, they will allowed in the meantime. But here the Archaeological Survey of India had clarified that Tourism Department had never issued identity cards. It is only the tourist officer without consent of the Tourism Department had issued the same. Now, my lord, for an interim arrangement, I'm humbly submitting that, my lord. Here, for giving compensation during funny, the collector as well as sub-collector had identified 268 numbers of photographers. So, my lord, since 6/3/2023, they are not allowing a single photographer to enter into the Konark temple, my lord. Yes. That is my predicament, my lord.
paragraph. It is accordingly directed that the proposal submitted by respondent number 12 for forest diversion be considered in accordance with law by the state government. And after hearing opposite party number 12, a reasoned order should be passed in that regard, not later than 1st July.
I'm sorry.
1st July 2023. An affidavit be filed by the state government, placing on record the decision before the next date. List on 25th July.
I'm so grateful. I'm so
My lord, a small correction only. We are appearing on behalf of opposite party number 12 in Bharat. The management has been taken over, so it will continue on.
Management, yeah.
Well, I am for the open number 1 and 3.
All right.
Item number 34.
34, my lord, on behalf of the Central Pollution Control Board, I pray 2 weeks time to file respond to the report of the state government, my lord. I've sought for
Mr. BP Tripathi, learned counsel appearing for the Central Pollution Control Board, seeks and is granted 2 weeks time to respond to the report submitted by the state government. State government in the present matter. At his request, list on 23rd June.
Oblast.
1 minute. So it can be, 26th June. 26th June. No, 1 minute. That's also every day there is something. Sixth July. I think 6th July. 6th July. All right.
Item number 35.
35, my lord. I have received the affidavit filed by OP2. I seek some time to file rejoinder to that, my lord.
Last option to file rejoinder for the next date. List on 5th September.
Item 36.
That personal appearance was there, like the Tahsildar. That may be
The
displayed.
personal appearance of the Tahsildar
Tahsildar
is exempted. All right.
And we have filed the counter in time. We have filed the counter in time. That 25,000 cost maybe waived. We have filed the counter in time.
All right. Since the counter affidavit has been filed within time, there's no requirement for payment of costs. All right.
Item
36.
Relating to the construction of road, village road from the district mineral fund matter. As per instruction, yet it is not completed. And government, state council have to apply this about the status of the road.
Yes, that status report is there. Just now
You have to file it with an affidavit, sir.
I have received the instruction in government letter. If you're not, otherwise I will file.
You have to give him a
Yes,
copy.
I'm giving.
The instructions received by Mr. Malpi be placed before the court with an affidavit before the next date with an advance copy to constitute the petitioner. List on 3rd July.
Item number 37.
Item 37 at the outset. And the second item I am appearing for one of the opposite parties. My lord, there is some affidavit filed by the state with a report. And my lord have directed that report is to be supplied to me also. All the parties, but I have not received. May I request my friend to give a copy? Petitioner, they might have given it to the appellant, but not to us.
Earlier, Mr. Gopal Mahanti was appearing, copy was served on him. So I can serve in course of
Best is you take a copy from the courtmaster, sir. Give a pen drive.
Because I got a noting that none of the parties are, so I think they will give it to all. They have given to some. Otherwise, I would have requested my friend to get a copy. That is not a issue.
Collect the soft copy of the
Yes, I will
paper
collect. Now I will collect.
It will be open to the parties to collect on a pen drive soft copies of the paper
All the entire
from the courtmaster. All right. List on 13th September.
Item number 38.
38 I thought.
Item 38.
May I please?
Lordship, I prepare a date chart. Kindly.
Who's for the other side? Who's for the other side, sir?
Yes, I am appearing for the state and also opposite, someone is appearing for. I am for opposite pattern 1 and 2. The DGT normally one because then appears.
NCVT. What about them? Who's appearing for them?
Central Government Council Chandrakanta Pradhan's name appears.
Not. But somebody is to appear for them, na?
Yes, ma'am.
Mr. Padi,
Yes, Mr. Padi can appear.
I see. It appears. It is seen that while Mr. Kuntia is appearing for respondents for
1 and 2.
1 and 2, none is today appearing on behalf of respondents 3 and 4. Earlier, who was appearing? The order sheet will show that. A copy of the complete set of the papers be served upon Mr. P.K. Padi under DSG Act to enable him to take instructions. This you can give back, this list of dates, give it back. Next time you can give it. List on 18 September.
At any time in August, anytime in
It's
August.
It may not reach at all if you give it August date. Right.
Item 39.
Lords, on the pretext of a pending consultation proceeding, the Honorable Single Judge has passed an order directing BDO to pass orders on the representation and conditional status quo order. Lordship, see page 10. Lord, now that the consultation proceedings are already disposed of, I'll just request your Lordship to direct the BDO to dispose of the representation. But in fact, that would be in their favor.
It is seen that by the impugned order of the judge.
Challenging the order of consolidation of collector, my lord, I have already filed a writ petition that is pending, my lord.
Let the BDO pass the order.
Yes.
The impugned order requires the BDO to take a Simulia to take a decision within 4 weeks. Full stop. If not already taken, the decision will be taken within a period of 8 weeks from today.
That will do.
In accordance with law.
Great.
No further directions are called for. A copy of this order be sent to the BDO Simulia.
Yes.
Writ is disposed of in the terms.
Item number 40. Item 40.
Madam, this is Saptapadia case, madam. Notice has been issued. There was some delay, therefore we were directed to pay the cost. Cost has also been deposited. The direct payment matter.
But neither notice nor undelivered.
My lord, Lordship, if Lordship keeps it after vacation, awaiting appearance, my lord.
No fresh notice to respondent returnable. 12th September, interim order to continue.
Item 41.
Lord, item number 41 to 44. All these matters have become infructuous.
All right. Disposed of his instructions.
Item number 45.
45, my lord, pension rule matters. 25th of September, Lordship have kept the batch matters.
All right.
Item 46.
None appears dismissed.
47.
47, the matter was disposed of at the first date, and there's a noting that the counter has been filed, but though they say that I have therefore given the copy, but the copy is not available. Your Lordship may kindly see page 30. Page 30 was impugned before the Honorable Single Judge on the ground that the ADM does not have jurisdiction to pass an order of suspension. And Your Lordship, the impugned order which I am challenging of the Honorable Single Judge, Your Lordship may kindly see page 54.
Very first day.
My lord, very first day. And now he has decided, now coming to decide the other question, para 7 of page 54. Now coming to decide the other question regarding maintainability of the order wide Annex 6 being issued by the additional district magistrate functioning as the president, governing body of the college. This court records the submission of Mr. Mahanti Learned Counsel for the petitioner that there cannot be any dispute with regard to the fact, in absence of regular governing body of the institution involved herein, the additional district magistrate is the controlling authority of the institution for time being. In view of the matter, this court was of the opinion, in the absence of regular governing body, as the additional district magistrate is the discipline authority, there is no illegality in issuance of such order. Your Lordship may kindly see page 53, he has already quoted, and the judgment is also there of the division bench of this honorable court. For your convenience, the relevant pages have bought.
So the ADM never becomes the.
My lord, no. My lord, here I am appearing for respondent number 7. I filed counter affidavit.
Your Lordship,
respondent number 4, I appeared.
Sir, the point is it had to be done before a single judge, not on the first day.
My lord,
yes,
ADM has the power. ADM has the power. I have annexed the documents, annexed to A by 2.
You have to tell the.
My lord, annexed to A by 2. Counter affidavit filed by respondent number 4.
Your Lordship, the judgment passed by this honorable court.
ADM has been vested with the power by virtue of the government notification.
So place all that on record so that he can meet the case, sir.
My lord, I have already served the copy of the counter.
Which counter?
Judgment.
Counter by respondent number 4, my lord.
Here you have filed, is it?
Yes, my lord.
Oh, I see.
Let the matter be remanded back to the honorable single judge for because the law is well settled by the division bench, Your Lordship. The
Lordship plans to annex to A by 2 by counter.
Sir, if he has filed a counter here, we might as well decide it.
Then we'll, I will give a reply that the matter decided here.
Respondent 4 has filed a counter affidavit, copy of which has been handed over to counsel, the appellant and the state, both of whom are permitted to file a response thereto before the next date. List on 12 September.
In the meantime, respondent number 1 and 2 has filed their counter affidavit. Let a copy of the counter affidavit be served on me, my lord.
Counter affidavit of respondents 1 and 2 be served on
interim order
for respondent before. Interim order to continue.
My lord.
Item 48.
48 is for final disposal. Yesterday, I am appearing on virtual mode, Milos. Your Lordships have admitted and granted stay. It is for final disposal. Yesterday, we got the list late. Can I pray, Milos? It may be adjourned to some other day in July for final disposal.
All right. At the request of Mr. Shaktidhar Das, learned senior counsel for the appellant. List on 17 July.
25th July, Milos. Can I pray 25th July?
All right, 25th July.
Oblige.
Item 49.
In item 49, I'm appearing on behalf of Satya Mohanty in this case, my lord. My lord, the counter affidavit filed by the R1 has not been served upon us.
Copy of the counter affidavit filed by respondent 1 be served on counsel of the appellant. List on 11 September.
Much obliged, ma'am.
Item number 50.
Item number 15, similar matters are also dismissed. I am giving.
All right. All right. In view of the order passed with this court, this the writ appeal is dismissed. All right.
Pastor matter item number 10.
May I please, Your Lordship? May I please? With Your Lordship's kind permission, there are two writ appeals before this noble court. One writ petition and one writ appeal. Writ appeal is before Your Lordship on board. This is with regard to the decision of the caste scrutiny committee, which was challenged before the honorable single judge, and that having been confirmed, the writ appeal has been filed. The other writ petition relates to the termination order passed against me in pursuance of the decision of the caste scrutiny committee, which was not entertained before the then state administrative tribunal, and now a writ petition is pending. May I pray, my lord, both the cases may be taken up together after vacation, but this will impact each other. That is the difficulty, ma'am.
But that is before the single judge, no?
No, that is also before the honorable division bench because, my lord, it is against the order
of the 29092.
No, that's 8910 of 2013.
All right. List along with writ petition civil 8910 of 2013 on 31st August.
I'm grateful, man.
Grateful. Okay. I see.
The further investigation has been sought for, but without any permission, this further investigation will be carried out by the police under section 173(8), my lord. And I have been supported by judgment of the Honorable Apex Court, where it is stated that for further investigation, the court order is required, my lord.
Which order are you challenging?
Order dated, my lord, under Annexure 5, page 316, order dated 21/6/2021.
Your prayer clause is something else, sir.
Sorry, my lord.
Your prayer clause. Come to the prayer clause.
Please to.
There's no mention of this order at all in the prayer clause.
Yes, my lord.
Hmm.
I have to amend it. I'll amend it.
All right. At the request of counsel, the petitioner wants to amend the prayer. Let's go for the roster bench on 10 July.
Item number 5.
None please.
No. It's that 167(2) petition was rejected. What happened, my lord? The
Similar matters had come up before your lordship yesterday. Lordship had asked me to verify the conflicting judgments of the Honorable Supreme Court regarding NDPS extension of time in the
When
NDPS.
is that
matters.
coming up?
Lordship kept it after vacation. I'll verify the date, I'll inform.
Item number?
I'll verify and inform the court master.
All right. List along with serial MC, so and so on, so and so. All right.
5, 6, 7.
both 5, 6, 5 and 6.
Also 7.
All right. Same.
Item number 8. Sorry, 5, 6. Sorry.
Item 8. No, 5, 6, and 7, I think.
Yes, sir.
Item number 8.
Item 8 and 9, your lordships, on behalf of Mr. Mazdas, permitted to withdraw, your lordship.
All right. Dismiss is withdrawn.
Item number 10.
None appears dismissed.
Item 11.
May I please? My friend has argued, advanced his argument that whether on taking permission is required under section 173(8). That is the law laid down by the Apex Court in 70th Supreme Court. In the instant case, I have annexed, my lord, bare reading of the affair. After going through the same, this Honorable Court granted stay. There is no allegation against the present petitioner that he was involved in the alleged crime. The person who was involved, he has been caught red-handed, and there is no allegation against the present petitioner in the affair. Subsequently, my lord, a vexatious manner, a charge sheet has been submitted against the person who has been apprehended. That is the 20 kg of the contraband article has been
But
seized.
you can argue all these points now. Charge sheet has been filed.
My lord,
cognizance has been taken.
Like cognizance has been taken, but it is the mandate of law. The court has to apply the judicial mind. Under what purpose the investigation has been carried?
You can argue all this in the trial court.
Because your lordship knows that it's on last occasion, last week, while I have advanced my argument, your lordship directed me to come in a small quantity. This is exactly 20 kg only. There is no allegation. I was not present. Nothing else. Your lordship can see the affair. In the affair allegation, there is nothing, my lord. But later on, your lordship knows that is the judgment of the Apex Court. Somehow or other, in order to implicate the present petitioner, they have created a story. Neither the
See, please, of alibi and all have to be established, sir. It can't be done in a 482.
Because 173(8) is
Right.
very much clear, my lord.
Right.
That is the law.
All right. Permitting the petitioner to raise all three paper office. Petitioner is dismissed. All right.
Item number 12. Item 12.
None appears dismissed.
Item number 13.
Same one.
No, 13 millets, can it be taken up after vacation millets?
Why?
Lots of my senior will conduct the case, so he's little oddly placed. So kindly the matter.
Oddly placed. What's that oddly placed? Counsel the petitioner stated to be in some difficulty today. Let's look for the roster bench on 3rd July.
Obliged millets.
Item number 14.
Item 14, Malons. I'm appearing through video conferencing, Malons.
Yes, please.
Malons, here we are challenging the order of cognizance as it is directly against the orders of the Supreme Court, Malons. Malons, which says, Malons, this is an alleged chit fund company, Malons. Now, if your lordship kindly sees the order of the Supreme Court, which is at, if your lordships may see, this is in Subrat Chattoraja's case, my lords. It starts from page 21, Annex 3, and your lordships may kindly turn to page 64. Lordship gets it.
What's the status of the matter now?
Status of the matter is, my lords, cognizance has been taken. That's all, my lords.
No. Can't be.
All these matters were transferred to CBI pursuant to Supreme Court's order, my lords, as I understand, because they have taken an averment. My learned senior may be in a better position to say the status of the proceedings.
No. Who's for the CBI?
CBI.
The CBI.
Well, this is not a CBI case. This is a general police case. What I am saying is, as the matters have been transferred to CBI and CBI has investigated pursuant to the orders of the Supreme Court, the general police, as a corollary, the general courts will not have jurisdiction to try these cases. So, my lords, I will find out the status of the case. Your lordships may take
Mr. Milan Kanunga, learned senior counsel petitioner, seeks time to inform the court the present status of the case.
Yes, my lords.
At his request list before the cluster bench on 4th July. Right.
Item 15.
Deeply.
Item number 15.
None appears.
Item 16.
Same order.
17.
Same order.
Item 18.
17, no instructions.
No instructions. 18.
18 minutes to raise all the point at the time of trial.
All right. Permitting the petitioner to raise all, please.
Item number 19.
None appears dismissed.
Item number 20.
Permit to withdraw, my lord. All right. Permitting the petitioner to withdraw. Dismissed.
Item 21.
None appears dismissed.
Item number 22.
22, my lord. On behalf of Mr. Himanshu Mishra, he has gone to London.
What's the matter about, sir? The 2023 matter.
He's a senior advocate. He should argue.
That's not.
My lord, cognizance has been taken.
Order taking cognizance under challenge. Let it come after vacation before restoration.
No, charge sheet filed.
Yes, ma'am.
Oh,
Cognizance under challenge. After
permitting the petitioner to raise all, please, at the appropriate stage. All right.
Item 23.
None appears dismissed.
Item number 24.
May I please, Lordship? Lordship, in this case, I am appearing for the OP number 2. Lordship,
All right. None appears to the petitioner.
I am appearing for the petitioner.
Tell us.
Matter has been amicably settled by the.
Oh.
Yes, Lordship. Kindly.
Counsel appearing for opposite party number 2 produces the affidavit stating that parties have settled their interstate disputes. 376, madam. Only Vakalatnama has been filed. It's 376.
Lordship, due to some misunderstanding, affair has been lost.
The IIC will confirm the genuineness of the affidavit and inform the court on the next date. List before the roster bench on 11 July.
25.
May I please? Lords, 25 milords, I do not press the IA, milords. I do not press the IA. So far the CRLM is concerned, milords. I am challenging the entire proceeding. Milords, offences are triable by magistrate first class. And milords, here the informant is the IIC himself. So far allegation against the petitioner is concerned, milords, he pulled the uniform of the officer. That is the allegation during the last local body election. Now, your lordship may kindly see page 37.
Charge sheet has been filed.
Cognizance has been taken and process has been issued. So far other accused persons are concerned, your lordship may kindly see page 37. The informant says, informant is the IAC.
Trial is already going on. Looks like.
No, milord, trial has ended. Milord, the matter has been, trial has ended. So far the other accused persons are concerned. Now the informant says the matter has been amicably settled.
No.
Look, page 37. Page 37, your lordship may kindly see.
Yes.
Page 37. I am the examination in chief. I am the informant as well as the victim in this case. I know the accused persons present in the dock. The incident took place on 24/3/2022.
Then you produce the affidavit of the informant here.
My lord?
You produce the statement or affidavit of the informant here then.
My lord, he is the IIC himself, my lord.
How will he give that affidavit?
My lord, this is the evidence before the court. Evidence before the court.
Okay, you take instructions, sir.
Yes, ma'am.
Counsel for the petitioner states that in respect of the co-accused, the informant already has made a statement on oath before the trial court that the disputes have been settled. Paragraph. Counsel for the state seeks time for instructions. This before the roster bench on 11 July.
Item number 26.
Item number 26, my lord. Quashing on the ground of compromise, my lord. Annexure 9, page 52 is the compromise petition, my lord. And my learned friend is appearing for the opposite party.
I am for opposite party 3.
What is the offense, sir?
Offense, my lord, your POCSO Act as well as 376. Even if my lord is the adopted daughter, my lord, is the adopted daughter, and your lordship kindly see, because she has left with another boy, I lost this FIR. Subsequently, she has alleged some due to some misunderstanding, she has
just checked, sir. Ask the IAC to check. The IAC of the concerned police station.
And now she is also residing with
verify
me.
the affidavit filed on behalf of opposite party number 2. And
Opposite party number 3, my lord.
3, all right. And inform the court on the next of its genuineness. This is all. 12 July. For the rest of
Item 27.
May I pray, my lord, I am filed a miscase for stay of NBW, my lord.
No, sir. Yes, sir.
27.
None appears dismissed.
28.
May please, your lordship. My lord, conducted counsel, Mr. father admitted in the ICU.
Or counsel of the petitioner stated to be in some difficulty today.
My lord, may I pray one thing, my lord?
On 5th July.
Item 29.
My lord, item 76 and 77. Kindly order for the same.
All right. Same date.
76 and 77.
All right.
Oblige, your lordship.
Item 29.
None appears dismissed.
Item 30.
Same order.
Item 31.
May I please, your lordship? My lord, I have filed I for correction of order. Recall of the order, my lord. Matter has been compromised. Informant also appeared and filed affidavit, my lord. Due to wrong sanction, order has been passed, my lord. Matter has already compromised and a settlement between the
For the
parties.
reason stated therein, the order dated 5th May is recalled and that he is allowed. And CRLMC's 972 is restored to file. What's the offense, sir? What are the offenses?
My lord, 307, 326 and other offences, sir.
Which are the offenses, sir? 147, 140. All right. There's an affidavit. Who's filed?
I am appearing.
Counsel appearing for the opposite party number 2.
My lord.
Confirms that the disputes between the parties have been settled. The affidavit is also on record. In that view, the matter takes from the prayer clause and all proceedings consequent that is record.
Okay. Item number 32.
None appears dismissed.
33.
Same order.
Item
33, you're there.
May I please, your lordship?
Item 32, your lordship.
Yes.
Item 32, your lordship, needs to be taken. I'm on behalf of Mr. Lal. Notice has been unserved, like undelivered. That's what the voting says.
She's seeking quashing of FIR. Charge sheet has been filed in the meantime.
Charge sheet already filed, madam, permitting the petitioner to raise all pleas.
Yes, your lordship.
All right.
33.
May I please, your lordship? Lordship, here I am challenging the order of dismissal of discharge petition of the petitioner. It's because he was the president of the Regional Cooperative Marketing Society, Bhanjanagar, and sold a piece of land to the highest bidder by following all
Trial is
the...
not commenced.
No.
Yes.
Lordship, there is no quid pro quo aspect in this case. And matter may be reported.
Not convinced, sir. Counsel for the petitioner, you will raise all pleas later. Counsel for the petitioner seeks leave to withdraw the present petition, reserving the right to the petitioner to seek to raise appropriate defenses in the course of the trial. Disposed of is withdrawn with liberty spring.
34.
34 Lordship challenging is for defreezing the bank accounts of the petitioner. Lordship, the bank accounts were seized during the investigation, and it is just because the investigation was going on, the same was not allowed to be defreezed. The case is out of a complaint case. And
what is the present position?
Present position, investigation is over. Lordship, charge sheet.
No. Regarding the bank accounts,
it's not a defreeze, Lordship.
28 July.
Lord, page 20, my lord, your lordship may kindly see detailed reason has been given by the London Session Judgment.
I think here we simply say permitting the petitioner to raise all pleas. Correct.
Item 35.
None of this.
36.
So the item 36 frame for after vacation.
Why?
So my senior will argue this matter.
No. Tell me what the matter is about. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item 37.
May I please, Lordship, my lord, I pray raise all the pen in court below.
All right.
Oblige, Lordship.
Permitting the petitioner.
Item 38.
It may be permitted to withdraw, my lord.
All right. This was withdrawn.
Item 39.
Watching of the proceeding. I am for OP number 2. Due to some inconvenient, I could not file the affidavit, compromise affidavit. Offense under section 363. Both are residing.
Counsel for the opposite party number 2 seeks time to produce the affidavit of opposite party number 2 to the effect that the disputes have been settled. That is requested for the roster bench. 5th July.
Obligement.
Item number 40.
None appears dismissed.
41.
Same order.
Item 42.
My lord, here the petitioners are in-laws, my lord, brother-in-law and sister-in-law. My lord, here the opposite party number 1 has married to the brother of the petitioner number 2, my lord. After the death of her husband, the opposite party number 1 has filed a CP case number 157 of 2021 before the family judge Bhadrak for maintenance, my lord, and added the present petitioner as opposite party in that case and demanding maintenance from the present petitioner. But the present petitioner are residing in another place. They are the brother-in-law and sister. They are no way connected.
Point out to the concerned courts. This is only maintenance case.
Well, they have with false and frivolous allegation he has made that there was demand of dowry and he left. She voluntarily left the house of the
permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. Right.
Item 43.
May I please, your lordships? In this matter, the petitioners and opposite party number 2 have entered into a compromise. And in the your lordship may kindly have a glance at page 26. Before the judge family court, the opposite party number 2 has admitted, has accepted that she will withdraw all the cases. And on that ground, the mutual divorce was ordered between them. And after that, the opposite party number 2 is also remarried and she is living happily. But for that, probably she doesn't want to come to this court. The lordship may kindly guide them if they can take instruction on that basis. It can be disposed of, my lords.
No, but who's appearing?
So notice was one, but notice has
unserved notice.
Unserved notice.
No, is it served? Neither AD nor unserved. Best is you take all the pleas at the appropriate stage, sir.
Well, sir,
not served. So notice is also not getting served, sir. Endlessly it will be kept pending here.
Well, if the state can take the instruction from the opposite party number if she wants to proceed.
She's not traceable. What do you do? Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
Item 44.
None of these dismissed.
45.
Item
Yes.
45, Your Lordship. My learned senior has been to Sambalpur, Your Lordship. I pray the matter may be taken up tomorrow, Your Lordship.
No, what's the matter about?
Your
In
Lordship.
Sambalpur, we have a nice virtual court. You can easily appear from there. What's the matter about? What is the matter about?
Lord, challenging the order of taking cognizance, my lord.
Yes, Your Lordship.
What is the ground?
My lord, after charge sheet, my lord, this cognizance has been taken.
All right. Permitting the petitioner to raise all please the appropriate petitions discussed. All right.
Item 46.
This is my lord. I will raise all the points.
Right. Right.
Item 47.
None appears dismissed.
48.
Item 48, I'm praying for Passover, your lord.
All right.
God bless.
Item 49.
Please to lordship, some defect is there, my lordship. Maybe
It's a
given
2021 matter. What is it about? Tell us.
my lordship. The fact is that actually the case has been registered, and it's a dispute going on in the civil suit in the Barampur civil court, my lordship. Means the owner was present, but in presence of owner, the family member of the same, but they doesn't belong to the owner.
Who's
The
appearing?
house.
Notice what happened. Who's appearing? Have you served the other side?
No, state.
No. There's a private opposite party.
I have filed against the IAC of police station.
No, there are two. One is IAC, the other is sub-inspector, and then fourth is some Sumitra
Notice
Behra.
has been served, my lordship.
Sorry?
Notice has been gone, my lordship.
Gone is one thing, service is another, madam. Simply notice going is not the point.
My lordship, I served the second copy, my lordship.
No, where's the second copy? You have to actually serve the opposite parties. Proof was from opposite party number 2 only. You said it doesn't appear that it appears that respondents, opposite parties 3 and 4 are yet to be served. Fresh notice return for the roster bench on 10 July.
Placements.
Item number 50.
None appears list.
Item 51.
Same order.
52.
Yeah, Lordship, AD has not back. I will take a first step for the issue open issue notice of.
Let's see what the matter is about, sir.
Challenge the order next 4 and 5, Lordship. The order of cognizance always along with the.
By now, charge sheet would have been filed, sir. 3 not 2.
Lordship, after 6 years, the FIR was lodged in 2013.
Solid 3 not 2, sir.
Charge sheet was filed in 2019,
Yeah.
Lordship.
Solid.
With the statement of co-accused, Lordship.
Solid. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item 53.
Interim modification.
53.
None appears dismissed.
Item number 54.
Same order.
55.
Item 55, I'm praying for praying for liberty to raise all that.
Permitting the petition.
Okay.
Item 56.
None appears dismissed.
Item number 57.
Same order.
58.
58, Lordship, permitted to withdraw.
Order. Dismissed is withdrawn.
Item 59.
59, my lord. I may be permitted to liberty to raise
Raise
all
all
the points.
pleas. All right. Permitting the petition.
Item number 60.
May I please yours? True case for quashing the loss. I am on bail. 205 application has been allowed. It's not for any other purpose.
I am for the informant.
All right.
Earlier he has approached this honorable court.
I
in
don't think, my lords, either he is advocate general or a senior counsel having right to pre-audience. Let me place my case. He will have his say.
Right. What is the status of
Stage, my lords, here is very peculiar, my lords. Now,
for evidence. For evidence.
All right, let him answer. All right.
Now, I am the president of a Yoga Kriya Foundation Trust. The trust is, the ashram is in Rishikesh and in Bhubaneswar. We run schools and some international centers for promotion of Yoga Kriya. Now, foreign donations come in. Due to internal feud, somehow or the other, this person claiming that he has given 1,000 euro as donation. Subsequently, he said, no, it's a loan. Then, a agreement was executed and money has been paid back. Still then, he never instituted any case there where the occurrence took place, came to India for reasons that's known to him, instituted a case under 420, and it has been registered with 3-4 further allegations, my lords. Now, preliminary charge sheet was submitted. At that stage, I approached this court in a criminal revision. On 2 points, it was rejected, saying final charge sheet has not yet come, and FIR somehow makes out some allegation. No disputes, my lords. Then I filed an application for discharge. Court rejected it, framed charge. After framing of charge, your lordship knows the stage means to raise this case at the time of framing of charge. Now charge has been framed. Now charge sheet, final charge sheet comes after that, indicating no, there are no multiple transactions. This is the only transactions for which evidence is gathered. If this is the only transaction and an agreement was signed, money has been repaid, no case survives. So there is a huge difference. Now I cannot go back and ask the court, the learned court has no power to reconsider his own order once he has framed charge, and the charge sheet comes after framing of charge. So,
who's on the state?
Yes.
Is it right that charge sheet has been filed after framing of charge?
Yes, lords. It's the order sheet I have filed.
No.
Yes, lords.
Preliminary charge sheet filed.
Supplementary charge sheet after charge is framed.
Yes, para 6 I have specific.
No, it is not. And I am placing the order sheet of the
order sheet also I have
trial court. It has posted for evidence. And earlier he has approached this honorable court for quashing
I have already stated that.
That he said, sir.
That this honorable court says that is a prima facie case.
No. Is there a supplementary charge sheet filed after framing of charges?
My lord, para 6, lordship may see my abhorrement, page 6 of my brief. Last 5 lines.
Not hold good unless the document is filed. Is to show the.
My lord, my learned friend had not gone through my brief nor annexures, to be very frank and honest.
You file a reply then.
Yes, my lord.
One of the contentions raised in para 6 of the petition by the petitioner is that after charges were framed, a supplementary charge sheet has been filed. Where have you said that?
Para 6, my lords. The dates I have given, last part, honorable court interfered. Thereafter, the learned court also proceeded to frame charge, and the petitioner filed application for discharge, and the same was rejected on 18/5/19. After rejection of the said application, the final charge sheet was filed on 24/10.
After the discharge application was rejected on 18/5/2019, a final charge sheet was filed on 24th October 2019, and charges were framed on.
That is the order sheet, my lords, I have annexed.
My lord, your lordship may kindly this same. The final charge sheet was filed in the present case on 24/10/2019, and charges were framed on 5/3/20, my lord. After that, my lord, charges were framed after filing of the final charge sheet.
That's correct only, sir. It's not the other way around. You made it seem as if this was filed after charges were framed. That's not correct.
And Supreme Court direction is there targeting the trial. Supreme Court direction from in this case. I have approached the Supreme Court.
Let him produce the charge sheet. Let him produce the records, my lords. The
direction from the Supreme Court for conclusion of the trial in one period of 1 year.
I am not. There is no delay. Millers may kindly see.
In 2017, and because of this, it is going on lingering, and it is posted for evidence.
Oh, yes.
It is also posted for evidence.
This court is informed that the matter is now posted for evidence.
My lords, it's posted for evidence since when? Let him say that. Since last 4 years, 5 years.
Yes. No. It is not correct. He is not cooperating. This is the order sheet of the lower.
And the trial is not progressing.
My lords, this kind of, with due respect, my lords, this kind of hearing something he throws. My lords, now question is, my permission after my application was dismissed, my discharge application, the final charge sheet comes. So I should have an opportunity to raise it there before that court at least. Because order sheet, my lord, may see. My lords, annexure 6, page 32. Order dated 18/5/19.
The trial has to commence. Let the trial commence.
My lords, trial is not commencing for the 3 years.
Your lordship may target the trial.
No, that is not the purpose, my lords.
Yes.
My lords,
Because of the pendency.
my lords, I may be given a liberty to raise it there.
Expedite the trial, sir.
My lords, I may be heard then with full detail.
No. You see,
My lord, no. Where is the opportunity of being heard? My lord, my lord, turn to annexure 6, page 32.
yes.
18/5/2019.
Correct.
Yes. Then next order. 5, my lord.
Charges were framed after the charge sheet was filed, sir.
Yes.
After final charges was filed, charges framed.
My lords, where is the scope for filing an application for discharge? That is the scope for an accused to have his say before the trial court. That's what I am saying, my lords. My lord, may see. Next order. 5/3/20. Without hearing me, without
make
the
it
final
clear that the
document,
trial will not be stopped. Let's make it
I
clear.
have not filed any interim application. I made it clear, my lords. It's not my purpose to delay it.
All right.
I may be given a
Once the
chance
petitioner
to.
assured the court that he's not interested in delaying the trial,
My lords, I
but
may
only
be.
wants to press the present petition on the short ground that before the final charge sheet was filed, his application for discharge was dismissed, and after the final charge sheet was filed, charges were framed. His grievance is that he was not given an opportunity to argue on charge vis-a-vis the final charge sheet before the trial court, and therefore that opportunity cannot be denied to the petitioner. Paragraph. Counsel, the state wants to seek instructions specific to this point. We'll stop. List before the roster bench on 4th July.
My lords,
It is made clear that the trial has not been stayed by this court and should
no, I am not.
progress
Application is there, my lords.
in accordance with law.
My lords,
Copy
another.
of this order be sent to the trial court forthwith.
My lords, another small problem is there. Last occasion, 2 honorable judges refused to hear this petitioner's application.
That whenever
So your lordship has referred it to my lord Justice D. Das, my passport matter and other thing. That is in criminal revision number 697.
we'll see what happens. We don't know. We'll just see what happens.
All right.
Item 61.
None appears dismissed.
62.
Please, madam. My lord, here, my lord, I am challenging the issuance of NBW. My lord, the petitioner is the owner of a vehicle with the said vehicle was also
NDPS Act, my lord.
the said vehicle also detained and the accused also apprehended at the spot. There was no FIR against me. Neither I have been made as an accused. Only because the NBW has been issued because my vehicle has been used for carrying the contraband article. Only my prayer is allow me to surrender. I am ready to cooperate.
So I'm not willing to do that. Not in NDPS cases. What do you wish to do, sir?
Sir,
because considering that the offence is under the NDPS Act, this court is not inclined to interfere with the NBW already issued and pass an order permitting the petitioner to surrender on a particular date. The petition is accordingly dismissed.
Item number 63.
None appears dismissed.
64.
Same order.
65.
May I please, Your Lordship? Lordship, item 65 and 66 permitted to withdraw, Your Lordship.
All right. Dismisses withdrawn.
Item number 67.
In this case, Your Lordship,
67. 67.
I am in VCLRC. I am instructed to appear on behalf of the opposite party number 2 LRC.
Who's for the petitioner? You're withdrawing this also, right? 67?
LRC, the matter has compromised LRC. The affidavit has to be filed LRC.
Oh. Counsel appearing for the opposite party number 2 states that the disputes between the parties have been settled and he seeks time to file a compromise petition.
I am for the petitioner, LRC.
All right. List before the roster bench for that purpose on 5th July.
68.
68, 69, 70 and 70 LRC permitted to withdraw.
All right. Dismiss is withdrawn.
Item 71.
My lord, on behalf of Mr. Rath, may I pray for an adjournment after vacation, my lord.
Why?
My lord, he has some health issues, my lord.
Counsel for the petitioner state to be unwell. List for the roster bench on 17 July.
Item 72.
May I plead, Lordship? Dear Lordship, the matter has been compromised between the parties.
What's the offense, sir?
307 and other offenses are there.
May I please,
Case
Lordship?
9, Lordship.
Lordship, in this case, I am appearing for the informant. Lordship, matter has been amicable settled. Lordship, kindly accept my wakalatnama and affidavit, Lordship.
Counsel appearing for opposite party number 2 tenders an affidavit which states that parties have amicably settled their disputes. That is the matter, taking prayer clause and all proceedings consequently.
$73.
Lordship, permitted to raise all the points.
Right, permitting the petitioner's office.
Item 74.
None of it's.
Item 75.
Pardon me, Lord, I am in a virtual, my Lord.
Yes.
My Lord, offense under section 302, 201, 120B, read with section 25, 1BA, 27 Arms Act, my Lord. As per your Lordship's direction, the petitioner came before your Lordship after filing of charge sheet. And in this case, some of the co-accused persons already released on bail. The petitioner is in custody since 29/2020, my Lord.
Want to take instructions, sir?
Yes, my Lord. Your Lordship may kindly see the rejection order, my Lord. There are altogether 45 witnesses.
What is the status of the trial now?
My Lord, the trial is going on.
No. Independent witnesses have been examined or not?
5 witnesses have been examined.
Which of them are independent witnesses?
My Lord, independent witnesses are yet to be examined, my Lord.
You tell us which ones, sir.
Lord,
you have to indicate how many witnesses,
yes,
how many are former witnesses, how many are independent witnesses.
Lord, I will take instruction.
Counsel for the state wants time for
In
instructions.
BLAPL number 1020 of 2021, also one of the co-accused, Gurunath Bhatta, already released on bail. By this
This accused is the main accused. He has got the throat and neck of the
present status of the trial.
Nakul and Raghunath is the prime accused, my Lord. I am only present. I am not the involved in this case, my Lord.
7 July, sir. Sorry. Yes.
76, 77 taken. 78.
On behalf of SP Das, ill my Lord, kindly taken over after vacation, my Lord.
He's unwell.
Ill, my Lord, suffering from fever, my Lord. On behalf of SP Das, my Lord.
Counsel for the petitioner state to be unwell. Let's go for the roster bench on 17 July.
Item 79.
Please, your Lordship.
Yes.
There are 4 matters tagged together. The 482 application, my Lords, relates to initiation of a proceeding under section 144(2) CRPC, my Lords. If your Lordship will look at annexure 1, Lords, page 8. This Premananda Das, who is the first party, my Lords, he is a member of the scheduled caste, my Lords. Taking advantage of that, my Lords, he initiated a criminal proceedings which is pending before the learned special judge Gajpati, my Lords. And in that criminal proceeding, my lords, the petitioners had approached your lordships for anticipatory bail and they were directed to surrender. Certain conditions were imposed, my lords, which are not available in the CRPC to be imposed. And the first condition was that they will hand over possession of the land within 15 days from the date of their release on bail. The second condition, my lord, another condition was that these petitioners will not obstruct the informant in any manner, and certain other conditions were there. While granting bail, the special judge, my lords, directed the SDM to initiate a proceeding under 144. If your lordship will look at page 8, my lords may see, peruse the order passed by the special judge Gajpati in GR 24 of 2020. It's revealed from the order that the informant is claiming to have purchased a piece of land by registered sale deed number such and such, out of which such and such extent of land has been recorded in the name of the first party, wide plot number such and such, khata number such and such of Mauja Paralakemundi, and acre such and such of land has been recorded in the name of Sadaram Mutt in plot number 2114. And
these are all vacant lands or agricultural lands? What are these?
No, my lords. These lands belongs to the Mutt, wherein certain persons, including the petitioners, they have paid salami to the Mahant and have constructed temporary dwellings and are residing, my lords. The allegation, my lords, that these lands belong to the informant is misconceived, which is apparent from page 11, my lords may see. That is the order of the order of the land reforms officer, my lords.
You are the informant.
My lord, I am moving number 2 in each case.
My lords may look at page 11 of that order. He writes, on the contrary, the contentions of the advocate for respondents are that Sadaram Motto is a public indexed motto and property if alienated in favor of the father of the petitioner and others by the Mahanta is not valid and binding as per the provisions laid down on section 19 of the Odisha Hindu Religious Endowments Act. Contention of the advocate for petitioner that Hall plot number 2114, 2116 and 2117 presently recorded in the name of the DT are from Sabik plot numbers 112 by 8 and 112 by 9 is not a fact.
This is an interim order under 144, right?
Well, Lord, the proceeding is continuing despite the life of an interim order being only for 60 days.
That's what I thought.
The ADM
how does he justify continuing the proceedings beyond 60
the
days?
executive magistrate, because it has been initiated on the directions of the special judge, is continuing with the proceedings. That is the subject matter of the fourth item in this list.
How can it continue, sir?
My lord,
144 proceedings, how can it continue?
Whether due to the stay granted by this honorable court?
No.
There is no stay granted.
Entering the property, not stay of the proceedings.
My lord, section OLR Act 23A of the OLR Act has been passed and they were directed to evict.
The competent authority under the OLR Act says, my lords, that this plot does not correspond to Sabik plot which he claims to have purchased. That is annexure 2. Despite that, my lords, these petitioners are now being subjected to litigation, my lords, before the special judge, before the executive magistrate, and they are now being harassed, my lords, taking advantage of the fact that the person belongs to the scheduled caste.
How can 144, so how can 144 continue like this?
My lord, your lordship, I have received instruction from the SDPO, my lord. There is, my lord, every possibility of breach of peace, my lord.
As on date?
Yes, my lord.
That has to be a fresh assessment, sir. It can't be endlessly.
Yes, my lord. I will take instruction.
Counsel to the state wants to take instructions on the so-called apprehension of breach of peace. Continuing till now. Stop when it was pointed out to him that this assessment is to be made periodically and that the life of a proceedings under section 144 CRPC
only 60 days.
Yeah, is only 60 days. He seeks time for instructions. You say interim order to continue. Let's go for the roster bench. 19 July. All the matters.
All matters.
Yeah.
Public.
Item number 80.
In item 80, my lords, the petitioner before your lordship, he has challenged the order of the learned court below dated 14/11/2019, framing charges against him under sections 420, 468, 471, 409, read with 120B and 34 IPC, my lords, in connection with a GR case pending before the Assistant Sessions Judge Gajpati, my lords. The prosecution case, my lords, was initiated on the informant's allegations, my lords, that he had received a notice for payment of outstanding loan dues from the State Bank of India, Paralakhemandi branch in respect of a loan account, but he had neither availed of the loan nor had applied for the loan or had been granted it. And he had received a demand notice and alleged that other villagers had also received similar notices. He alleged, my lords, that when Jagannath Bhuiya, peon of Machmara RI Circle, had taken the voter ID cards and passport size photographs of the villagers along with a sum of ₹100 per head to provide them record of rights after conversion of jungle lands, my lords. And he had, in collusion with the petitioner, who was the field officer of the agricultural loan department of the bank, had misappropriated the loan amount. My lords, in course of investigation, my lords, the petitioner was charge sheeted and he has challenged the order framing charge because the court below, while framing charges, has not taken into consideration the fact that on the date these allegations are said to have been made, he was no longer in service in the bank at that time.
But what you're praying for here is not the order, not challenging the order framing charge.
Yes, I have challenged the order framing charge.
No, come to the prayer clause.
The prayer is for quashing the proceedings as well as the charge.
Not the order framing charge. Not the order. That's a separate proceeding. You want to withdraw this, you reserve your liberty to seek other appropriations.
Your lordship,
but counsel the petitioner seeks leave to withdraw the present petition with liberty to seek other appropriate remedies available to the petitioner accordance with law. Disposed of his withdrawn liberties.
Item number 81.
Item 81, Lordship. I prefer an adjournment, Lordship, on the ground that my file has been misplaced and there is a compromise between the parties. The OP3 already has been filed the affidavit, Lordship. On the next date, I will submit, Lordship.
Who is appearing for OP number 3? All right. Counsel appearing for OP number 3. Mr. Hota. Sita Kanta Hota. Mr. S. Hota is not appearing today. The registry will telephonically inform him to remain present at the next date. Let's move for the roster bench on 24 July.
Lordship, pardon, my lord.
4th July.
4th July.
24th July. Interim order to continue. Right.
Obliged.
Item 82.
Lords, I'm appearing on Lord VC. Lord, in this case, peculiarly, Lord, both the accused persons have been pardoned under 306, and the proceeding is continuing against the company. So anyway, my lord, since there is no cause of action as on date, I seek leave to withdraw as and when both the keeping the legal issues open and liberty to refile if once it is.
All right. Disposed of is withdrawn with liberty spread for in the memory. All right.
I am appealing for
Lord, just one more line, if your lordship's indulgence, keeping the legal issues open, because if it can be continued against the company being unrepresented.
That is always available to
memo, sir. Right.
All
right.
Okay.
83.
Diplomatics. If him lord, this is the NI Act, Lord. Cognizance has been challenged. The part payment has been made out of the payment made by the complainant, Lord. For the entire whole amount, the check has been presented. That's the case.
Whatever, sir. Permitting the petitioner to raise all pleas in the appropriate petitioners disposed. All right.
Item 84.
May I please, Your Lordship? Rushdie, and the CRLMs they have
My lord, I am appearing for opposite part
it
number
has
2.
been filed.
Yes.
The cash has been filed on 30/6/2022, Your Lordship. So my whole contention is that the FIR, Your Lordship, may kindly see my Annexure 2.
Yes.
Annexure 2, the complainant filed in 2016. The entire allegation is of 2008 and 9, Your Lordship. In 2016, the complainant filed a complaint before the EOW CIDCB, which is at Annexure 2, alleging that he has taken a hand loan from me. As a guarantee, I asked him to make a sell deed in my favor, and in turn, when he repaid the loan, in the meantime, I has already sold off that particular land. That was the allegation. On that allegation, EOW complaint was filed. That was inquired into by Annexure 3. The inquiry report was filed that there is no substance in the allegation. Again, in the year 2021, on the self-same allegation on a twist of facts, the present FIR has been lodged, Your Lordship. In the present FIR, it was lodged that I have assured the complainant that if he pays me 20 lakhs, I assured him on a heavy return, Your Lordship. Accordingly, the FIR was lodged under section offences under section 420, 406, 294, 417, 506, along with the offences under PMLA Act, PCMC Act, and OPID Act. In the charge sheet, there is no offences under PMLA Act, PCMC Act, and the OPID Act. Only the offences under section IPCs are there, Your Lordship.
Let it be. The order framing charge has not been passed.
Not yet, Your Lordship.
So you raise all these pleas, man. Permitting the petitioner to raise all pleas at the appropriate station. The petition is dismissed.
Much obliged.
All right.
My lord, my appearance may be recorded. Opposite part number 2.
All right.
Obliged.
85 member. Lordship, I have challenged the order of discharge. The case is like this, my lord. The informant, the lady, he has lodged a FIR on 4/1/2021, alleging that at that time she was 22 years old, and she has stated that she was fell with love with the petitioner in the year 2015, and the petitioner false promised to marry her and keep physical relationship with her when she was aged about 17 years, 8 days and 8 months and 19 days. And he lodged the FIR on after 5 years. And on this allegation, the FIR was lodged and under the POCSO Act.
164, sir. There's a 164 statement.
So may I permitted to, I will raise all the points.
Raise all, please. Correct.
So only my lord, I pray till disposal of my petition, the stay may be there because in the lower court, because I will be prejudiced. I will raise all the points because that is the Supreme Court judgment, my lord. The false promise parry will not be offense. That is my lord. And they have only the allegation that when I denied to marry, she lodged the FIR at the time.
Petitioner raise all pleas at the appropriate stage. The petition is disposed of, interim order vacated. Yes.
Item 86.
86 on behalf of Mr. Subhasis Das. Matter may be taken up after vacation as he is very ill.
All right. Counsel, the petitioner is stated to be unwell. Let's move for the roster bench on July.
Deeply obliged.
87.
None appears dismissed.
And 85 may be one thing, my lord. I will, if he will pray for interim abstain, that will be considered by the lower court. That is sorry, sir.
Item 88.
May it please your lordships. Well, it's identical matters have been posted to 31st of July. That vicarious liability under the Income Tax Act, my lords.
All right.
And the principal officer, he has to be noticed under section 235.
Now, this is the past case.
Just a minute, I have not finished. You are launching prosecution like a routine manner.
Sorry.
Yes. And Supreme Court, my lord, has said that prosecution so far as 276B, 278A, that is the vicarious liability, should not be launched.
But when is it coming up? List along with?
Yes, my lord, along with my lord.
This is the past case. This is the past case, my lord, that will be following this case.
Yes, another case is there. You have appeared, you have filed it in submission. Why you are shouting here? I don't understand.
He's not
You take
In those cases, my lord, the Honorable Appeals Court held.
Shouting now.
The Honorable Appeals Court held whatever the grounds are there, that will be raised at the
Oh,
time
that
of trial.
that much water has flown through the Ganges.
In Madhumilan syntax case,
Madhumilan
Lordship,
case is gone.
already the Honorable Appeals Court in Madhumilan syntax case.
That is some other matter.
Yes, my lord.
Yes.
When is the connected matter coming up?
31st ballots, 236 ballots may kindly list it along with 236 of 2022.
22?
22 ballots.
That is subsequent.
Subsequent. Another year.
List along with criminal MC 20.
My lord,
2010 and 236 will be listed on the 31st of July ballots.
With 236 of 2020.
On the roast.
On 31st July, interim order to cut. All right.
He is outing. Doi Bakhada is there, my lords. He should cool himself. Entire bar is waiting for your lordship and the companion justices to come. And he is outing here on the day. My lords. Interim order to continue, man.
Interim order.
Much obliged, man.
Item 89.
Now for the informant, my lords, in 89. None appeals to the petitioner. Dismissal on possible.
Item number 90.
None appeals dismissed.
91.
I'm for the opposite party.
All right. None appeals to the petitioner. Dismissal on possible.
Item 92.
My lord, similar matter has been fixed to 22nd June. Your lord,
My lord, similar matter already disposed of. This is the order.
In view of the order passed on 25th April 2022 in CRLMC 2402 of 2021, the present petition is also disposed of in the same terms by directing that the numbers you change, CPC numbers so and so, arising out of, we disposed of in a period of 2 months.
93.
93, my lord. This is a default bail, my lord. Similar matter has been dealt with by coordinate bench. The Lord's special judge has extended the time beyond the stipulated. Page 27, man, kindly have a glance. The 180 days expired on 28 to 2021, but the Lord's special judge extended the period on 1/3/2021. Man, kindly my lord has dealt with all one and has passed the order 1/3. My lord, kindly have a glance to page 27.
This is after notice or before?
My lord, I may pardon.
Is this coming up after notice?
After page 27, man, kindly have a glance.
No, let notice go.
My lord.
Notice he accepts.
My lord, LCR has come. Notice has come. Trial court record.
Notice is not issued in this matter at all, sir. And why did you call for LCR? I don't think it was there. Which item are you appearing in?
93. Xerox copy. Page 27, kindly have a glance.
93 is 2443, no? So look what is
CRLMC 2443 of 2021.
2453, this got spelled.
2443 of 2021.
Matters issued 2443.
Finally, kindly have a glance to page 27. 180 days expired on 28 to 2021. The learned special was extended on 1/3. And the remand.
My lord, similar matters have been adjourned to a particular date, my lord. I will give that date, my lord. This will be hard, my lord.
Man, I may pardon in respect of the co-accused, it has been allowed. I have given the order. Page 5, my lord.
Are there other matters which are still coming up?
My lord.
He says there are other similar matters which are still to be heard.
Yes.
Are you aware of that?
My lord.
Tell us, give us the numbers. When is it listed?
CRLMC 1548 of 2021.
When is it coming up?
my lord has directed to come up on 27/6.
List on 27 June 2023 along with
CRLMC 1548 of 2021. My lord has directed the State Council to come up with the decision of the recent apex court judgment.
Item 94. Item 95.
May I please, your lordship? My lord, in this case, I have challenged the order of cognizance taken by the London magistrate, Annexure 4, my lord. And there is no prima facie case under section 307. And while submitting charge sheet, the IO did not add the offense 307 as against 1, 2, 3, 4 petitioners.
Permitting the petitioners to raise all pleas at the appropriate stage. The petition is dismissed.
96.
Yes.
Item 96.
Non-appeals dismissed.
97.
Non-appeals dismissed.
Item 98.
Item 98. This matter with regard to the compromise between the parties and there is assault counter assault, and in the meantime matter has been settled and notice was issued to the victim. Last occasion your lordship may say that notice was issued to the victim and implementing the party. So let it come after vacation, my lord, and you will appear in that case.
No, has she been served?
Yes, my lord. Notice was served.
15 accused. What is the matter about?
But this is with regard to
SC/ST and all. No question, sir.
Three SC/ST are
No
there.
question. No question.
My lord,
No question. Permitting the petitioners to raise all pleas is the appropriate stage.
your lordship, they have amicably settled the matter and
Question, sir. Absolutely no question. Yes.
99.
may I please your lordship.
Yes.
Challenging the cognizance order by the Annexure 1, my lord.
Yes.
Only my points, my lord. Legal notice not made sufficient. And for that reason, I am stated for page 7, para 9, my lord.
Yes.
I have stated, my lord. Wherein the legal notice has not made sufficient on the petitioner, which is a mandatory.
That you can raise all that please. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item 100.
Initially, I have challenged the order of cognizance, my lord. Cognizance was taken under section 13(2), 13(1)(c), my lord, PC Act, that is 109, my lord. So far as the present petitioner is concerned, she was not named in FIR initially.
Permitting the petitioner raise all pleas at the appropriate stage. The petition is dismissed.
Pass to matter item 48.
My lord.
Permitted you to raise all pleas, sir, at the appropriate stage. All right.
When item number 48, notice was issued, neither the AD nor on-sub notice received back from OP number 2.
What's the matter about, sir?
Well, it is a questioning of cognizance with husband and wife. Well,
you are there for?
Well, questioning of cognizance for offense under 498A.
You are the complainant.
Well,
No.
You are not in this matter.
No.
All right. We permit you to raise all pleas. Permitting.
Notice has been issued. Notice has been issued. Let them appear.
No.
But because ballot after 7 days of the marriage, she has left.
It's all.
It may be settled ballot taken up after vacation ballot.
No.
Because ballot may see after hearing me.
Yes.
Notice was issued with.
I know, but it's not.
I have filed requisites ballot on.
See, there are so many other matters you're seeing. If it is actually settled, you produce the affidavit.
Ballot?
Not like this.
I couldn't follow.
Permitting the petitioner to raise all pleas.
Well, at the stage of framing up charge, ballot.
Yes. All right.
Not at any stage, but at the framing up charge.
All right, at the stage of charge.
Because deliberately ballot say because they have divorced in the meantime.
All right.
May I please your lordship? I am Dr. Archana Kanunga. I am a national sports person. My case is in court number 1. As per the direction of Honorable Court, he said that with the permission of Chief Justice, you can put your matter to any other court. So
just give us the details. I'll ask them to place it. All right.